In the course of his opening statement, counsel to the inquiry will describe in greater detail the structure of Phase 2 and the individual modules which make it up. During the Phase 1 hearings, I heard a great deal of evidence, much of it of a very moving kind. Some witnesses were more controversial than others, of course, but I was very impressed by the way in which, day after day, everyone in the room listened quietly and respectfully while the witnesses gave their evidence, in some cases despite obvious difficulties. I'm confident that with your help, the Phase 2 hearings will be conducted in the same way, thereby enabling us to obtain the evidence we so badly need in order to answer the many important questions facing us. I'm going in a moment to invite counsel to the inquiry to make an opening statement, but I understand, Mr. Mansfield, that there's something you'd like to say before we do that.
Yes, thank you.
And now, would you like to make your way? Yes, if you would, please.
Thank you very much. Sir, Madam, may we thank you for this opportunity. It'll be very brief, to make a situation known to you and to enlist, hopefully, your assistance in attempting to resolve it. It arises directly from the resignation on Saturday of the panel member that you have referred to only moments ago. The families that I represent, and I represent Team 2 of the bereaved survivors and residents, are particularly concerned and anxious that the original objective, which was mapped out by Theresa May when she made the appointments in May of last year, and for additional panel members, and endorsed essentially by Boris Johnson just before Christmas, 23rd of December, using very much the same language, namely to ensure that the panel has a breadth of scope and skills, particularly with regard to social housing, community engagement, and participatory design and planning. And that is felt to be an essential part of this. And of course, there is a module devoted to part of it, but it spreads across all the modules, and therefore it is felt desirable to have the full panel from the beginning if possible. So far, the Cabinet Office and the Prime Minister, for that matter, have made no indication to the relatives or the group I represent, either on an individual basis, because many of them have met with Boris Johnson, others have met members of the Cabinet Office, others have written to the Cabinet Office, solicitors have written to the Cabinet Office. There has been a stunning silence. Not a word about whether there is going to be a replacement. Now, it may be there are all sorts of complications, but it would lend considerable force to this venture if you were able to make representations to discover whether they're going to or they're not going to, and what the difficulties are. So I just give a short example. If it's possible within the near future to have an extra panel member as originally envisaged, if that's possible without disrupting, because none of the families I represent want undue delay, and that is certainly not on the agenda. But on the other hand, to get this right, and it's not, of course, their fault in the first place, to get this right, if it means a short delay in relation to some of the evidence, then we would ask that the matter's investigated. But at the moment, we're operating in a vacuum, and we don't know the answer to this. It's possible today, and I think there may be, when I left my seat back there, apparently I'm told a member of or a representative of the Cabinet Office may be here today. And I would ask that some sort of indication is given as soon as possible so that we may act upon it in whatever way the families feel is desirable. So may I ask for your assistance on that matter, and thank you for allowing me to speak at this moment.
Well, thank you very much, Mr. Mansfield. Yes, well, in that case, Mr. Millett, I'm going to invite you to make an opening statement on behalf of the inquiry at this stage. Thank you.
Thank you, Mr. Chairman. Mr. Chairman, Madam, on the 30th of October 2019, Mr. Chairman, you published your report.
Forgive me, but you don't need to take the child out. No, really?
No, I'm just going to go through my baby.
All right. I'm sorry, Mr. Millett. Yes.
You published your report of phase 1 of this inquiry into the fire at Grenfell Tower on the 14th of June 2017. The subject of phase 1 of this inquiry was the events of that night. You examined in particular the cause and origin of the fire in flat 16, the mechanism by which the fire exited flat 16 and entered the cladding on the exterior of Grenfell Tower, how the fire spread around the exterior of the building and re-entered it, and the response of the emergency services, the council, and the tenant management organisation on the night. It also focused centrally and in detail on the many individual personal experiences of each occupant from flat to flat and floor to floor. Those appalling and all too often tragically fatal experiences provided the essential narrative for many of the lessons that you, Mr. Chairman, were able to draw about, among other things, the conditions within the building and its behaviour in that fire. Those conclusions, in turn, enabled you, on the evidence about those and other matters, to make wide-ranging recommendations for future change. So the question now is, what is phase 2 about? If phase 1 was about what happened to Grenfell Tower and at Grenfell Tower on the night of the 14th of June 2017, and the immediate causes and effects of the fire on the night, phase 2 is an examination of the reasons for why it happened. This, Mr. Chairman, as you have said, is the opening of phase 2 of this inquiry, and in particular of module 1. I propose to start by explaining in outline the overall shape of phase 2 and the modular structure that you, Mr. Chairman, have decided to adopt. I will then turn to the detailed issues to be investigated in the evidence at module 1. Let me begin by explaining in outline the shape of phase 2. In chapter 34 of the phase 1 report, you dealt with looking ahead to phase 2, and indeed that was the title of that chapter. In it, you identified a number of particular matters with which phase 2 will be concerned. Those included the remaining evidence relating to the circumstances in which the deceased's met their deaths, the London Fire Brigade, the LFB, and specifically the cause and origin of the shortcomings of the LFB's performance on the night of the fire, as were identified in the phase 1 report. The testing, classification, and certification of certain of the materials used in the external wall at Grenfell Tower. The design and choice of those materials by the professionals involved in the refurbishment. Fire doors, window arrangements, lifts, the smoke extraction system, and the warnings of the local community and the authorities' immediate response to the disaster. Phase 2 has been divided into 8 modules in which these and numerous other related issues will be examined. Let me now set out what they are. Module 1 will examine the role, acts and omissions of the professionals and other persons involved in the refurbishment of the tower from 2012 to its sign-off in July 2016. We will be hearing from a significant number of witnesses, including witnesses for the architect, Studio E, the design and build contractor, Ryden, the cladding subcontractor, Harley, the fire safety engineer, Exova, the fabricator of the aluminium composite, or ACM, panels, who was CEP, as well as the employer's agent, quantity surveyor, and CDM coordinator, Artelia, and the Royal Borough of Kensington and Chelsea's Building Control Department. We will also hear from the Kensington and Chelsea Tenant Management Organisation, or TMO, about their role in procuring the project and what they did as client. As I will explain in due course, Mr. Chairman, there will be particular focus on the materials selected for incorporation into the external wall as the project progressed and their compliance or otherwise with the building regulations and relevant associated statutory guidance, and in particular approved document B on fire safety, or ADB, as well as relevant industry guidance. I will return to a more detailed description of Module 1 a little bit later. We have timetabled Module 1 to run until the beginning of April this year. Module 2 will then examine closely the testing, classification, certification and marketing of key products used in the external wall, and specifically the ACM panels used in the rain screen system made and sold by Arconic, the polyisocyanurate, or PIR, and phenolic insulation used behind those ACM panels in the external wall construction, principally RS5000 made and sold by Celotex, which was PIR, and the K15 Cooltherm product made and sold by Kingspan, which was phenolic. The cavity barriers made and sold by Siderize, and the alu-glaze window infill panels. We will be particularly interested in, first, the key tests that these products underwent, particularly the Arconic ACM panels with the polyethylene core and the Celotex and Kingspan insulation. Second, their resultant fire classifications. Third, how those tests and classifications were represented by the manufacturers to their markets and to the two certification bodies, the LABC and the BBA. Fourth, the relevant certificates issued by the BBA in the case of the ACM panels and Kingspan's K15 Cooltherm product, and the LABC in the case of both K15 Cooltherm and the RS5000 insulation. And last, how those certificates were represented by the manufacturers to their markets, their buyers. We have timetabled Module 2 to start on the 4th of May with Module 2 openings and to hear the Module 2 evidence until mid-June. We have already provided core participants with a provisional and partial list of witnesses for Module 2 from manufacturers of the relevant material in the cladding system and from testing and certification bodies, and we expect to be able to finalise that list in the coming weeks. Module 3 will be divided into 3 broad topics. The first topic will investigate the complaints made by residents of the tower before the 14th of June 2017, which particularly relate to fire safety and concerns that were raised about doors and the quality of workmanship during the refurbishment. We will then examine the responses of the TMO and RBKC to those complaints and the degree of engagement by the TMO in the refurbishment works. Module 3 will then consider a second topic, namely compliance by the TMO, RBKC and the London Fire Brigade with their obligations under law, namely the Regulatory Reform Fire Safety Order 2005, otherwise known often as the RRO. A particular focus of our investigation at this module will be the fire risk assessments carried out by Carl Stokes and their adequacy. The final topic of Module 3 will contain the active and passive fire safety systems inside the tower, so lifts, fire doors, smoke extraction system, together with the gas supply system. Module 3 will run, including opening statements, from the end of June this year until early October, when we will have closing statements on all 3 modules 1, 2 and 3. The inquiry is intending to provide core participants with a detailed update regarding the structure of Module 3, confirmation of the relevant experts and other administrative matters in the early part of February. In Module 4, we will examine the performance of local and central government in the immediate aftermath of the disaster. Module 4 is currently timetabled to run from mid-October to mid-November this year. Module 5 will consider the adequacy of the firefighting response on the night of the fire. Important elements of that assessment were addressed by you already, Mr. Chairman, in the Phase 1 report, including the fundamental question whether stay-put advice could and should have been withdrawn before 2:47 a.m. There are, however, matters that require further investigation. These include the purpose and adequacy of Section 7.2d visits, the training of firefighters, including but not limited to incident command training, as well as alternative tactics for fighting fires in high-rise buildings, and communications and equipment, including the adequacy of water supply and pressure. Module 5 is timetabled to run from the end of November this year to mid-February next year, with a 2-week break for the festive period. Module 6 will involve a close study of central and local government's role in the disaster. And it will study in particular the responses by central government and other public bodies to previous incidents and reports, coroner's recommendations and things of that nature, including in respect of the building regulations and associated guidance, and fires and firefighting. In addition, and following on from the evidence which you will hear in Module 2, we will examine in further detail a number of aspects of the existing regime for testing, certification and classification of materials for use in external cladding systems, both in general terms and in relation to specific products. That examination will, we anticipate, encompass 4 things, at least. First, the routes to compliance with the requirements for external cladding systems under the building regulations and associated guidance, as well as the basis for each such route, including the practice of desktop assessments. Second, guidance produced by industry associations and standard setting organisations as to fire safety for the external cladding systems of high-rise buildings, and as to the compliance with the functional requirements of the building regulations for individual components of such systems and as a whole. Third, understanding across industry and amongst standard setting and certification bodies of the meaning and application of key test results and classifications. And fourth, the regulation and supervision of testing, certification and classification of construction products in relation to fire safety and performance in fire, including, again, the role of central government. Module 6 is timetabled to run from the 3rd week of February next year until early May next year, including a 2-week break for the Easter period. Module 7 will be devoted to the remaining expert evidence and will run for 1 week, until mid-May next year. The experts will examine the results from testing of cladding components and their final conclusions on the relative contributions of the cladding design and materials to the fire spread at Grenfell Tower, the adequacy of the testing regime investigated in earlier modules, and the conclusions to be drawn about the Grenfell Tower fire, including the lessons to be learned when comparing the Grenfell Tower fire with other fires, both domestically and internationally. Module 8 is to be for any remaining evidence and all submissions relating to the circumstances in which each deceased met their death, so far as not covered in the earlier modules and Phase 1. As to that module, Module 8, the bereaved, survivors and residents, or BSRs, have all been invited to provide written submissions by the 29th of May this year as to the further matters to be covered at Module 8. The timetable for Module 8 will await consideration of those submissions. Other than Modules 1 to 3, the closing statements, for which will be taken in one go in early October, each module will open and close with oral statements from core participants. Now, Mr. Chairman, this timetable that I have so far set out is obviously provisional and obviously subject to change. That is because this is an inquisitorial process and we must go where the evidence leads us. But it bears emphasising in strong terms that the work of this inquiry is urgent and delay, if there is to be any, must be kept to a minimum. There are clear public safety issues at stake which require us all to retain a disciplined and keen focus on the relevant issues. So, Mr. Chairman, that is the basic shape of Phase 2. I now turn to Module 1 in a little bit more detail. The inquiry has received detailed written submissions from 3 groups of BSRs and 19 commercial and institutional core participants, including 1 individual, Mr. Kevin Lamb. Each core participant has been allocated a space in the timetable for this week in which to make oral statements to you, and most core participants have taken up their invitation to speak. Having considered the contents of the core participants' written submissions or statements that they provided in December and in some cases in early January, the inquiry decided to give disclosure of each core participant's statement to all other core participants. It did so a week ago. The reason for doing so was so that each core participant could see and consider the position taken by the other core participants where they had put in written statements, and, if necessary, address the panel on any points it wished this week. That, in turn, was because, with the sole exception of RBKC, the Royal Borough of Kensington and Chelsea, not a single core participant involved in the primary refurbishment of Grenfell Tower has felt able to make any unqualified admission against its own interests. With that solitary exception, Mr. Chairman, one finds in these detailed and carefully crafted statements no trace of any acceptance of any responsibility for what happened at Grenfell Tower, not from the architects, the contract managers, the main contractors, the specialist cladding subcontractors, the fire safety engineers, or the TMO. Nor, with the exception of Celotex, who have made certain limited admissions which they assert were not causative, do we find any admission of any kind from those who made and sold the products used in the cladding. Any member of the public reading these statements and taking them all at face value would be forced to conclude that everyone involved in the refurbishment of Grenfell Tower did what they were supposed to do and nobody made any serious or causative mistakes. Now, Mr. Chairman, you will recall that in my opening address at Phase 1 of this inquiry on the 4th of June 2018, I invited the core participants not to indulge in a merry-go-round of buck passing. Regrettably, that invitation has not been accepted. Save for RBKC, who have made clear and welcome admissions of numerous failings of its building control officers, and to a lesser extent Celotex, each core participant who played a material part in the refurbishment of Grenfell Tower has laid out a detailed case for how it relied on the work of others and how in no way was the work it did either substandard or non-compliant. In every case, what happened was, as each of them would have it, someone else's fault. Now, at this stage, before hearing the oral evidence of the witnesses in this and perhaps also later modules, you are, of course, in no position to determine with whom and in what degree responsibility lies. However, you can, and you should, I would suggest, be guided, as you hear the evidence in this and indeed later modules, by two things. First, by the conclusion reached by you, Mr. Chairman, in your Phase 1 report, that the tower did not comply with certain key aspects of the building regulations. And secondly, by the expert evidence obtained by the inquiry and provided to core participants. As to the first of those, Chapter 26 of the Phase 1 report contains the Chairman's conclusion that the building was not compliant with functional requirement B41 of the building regulations. Requirement B41 required the external walls of Grenfell Tower to, quotes, adequately resist the spread of fire over the walls, having regard to the height, use and position of the building, close quotes. You, Mr. Chairman, concluded that far from resisting such fire spread, the walls actively promoted it, whether one considers the rain screen panels alone, the ACM panels, or the cladding system as a whole, or even the complete external envelope, including the concrete structure. Mr. Chairman, Madam, the notion that Grenfell Tower was not compliant with functional requirement B41 without anyone being at fault is unlikely. As to the experts' reports, the inquiry has been assisted by a very lengthy and detailed report from an expert architect, Mr. Paul Hyatt, and by several further reports from Dr. Lane on fire engineering, the health and safety file, and the question of whether Regulation 38 of the building regulations, which relates to handover of fire safety information, was properly complied with. We have also received a report from Ms. Beryl Menzies on the acts and omissions of RBKC's building control officers. Those reports, which were served on core participants at the end of October last year, identify a multitude of serious failings and departures from statutory requirements and guidance across a very wide spectrum of professional disciplines. You will, of course, bear in mind that those reports have not yet been tested in oral examination, and there are certain core participants who reject, at this stage, some of the conclusions reached by them. The reports of those experts will be published when they come to be examined at the end of Module 1, when they can give their opinions based on the evidence which has come out at that stage. However, on the question of accountability, it is important that I identify clearly at the outset what the inquiry panel is doing and what it is not doing. This module, Module 1, and indeed Phase 2 as a whole, is not a dress rehearsal for civil claims or any criminal proceedings. Indeed, you are expressly forbidden by Section 2 of the Inquiries Act 2005 from ruling on or making any determination of any person's liability, whether civil or criminal. Your task is to find the facts and to make recommendations. It is from the findings of fact, based on the evidence, that accountability follows. As part of the findings of fact, you may decide, as between a number of persons, who bears responsibility for acts and omissions. That will be based in turn on the contractual or statutory responsibilities that they were discharging and the way in which they understood those responsibilities and sought to comply with them. If lessons are to be learned from what went wrong at Grenfell Tower and the necessary changes to the construction industry are to be made, it is important that all those who give evidence at Module 1, and indeed all witnesses who are called throughout Phase 2, provide a truthful and a candid account of what happened during the primary refurbishment, so that your factual findings and recommendations that follow from them may accurately reflect the true nature of the problems which arose. Those who escaped from that burning building with their lives, or who lost loved ones and all that they possessed in that fire, are owed at the very least an honest and a complete account from those witnesses who are in a position to explain why it happened. I now turn to the issues for Module 1. The issues that we will be examining with the Module 1 witnesses broadly encompass the following. First, the initial decision to undergo refurbishment at Grenfell, the reasons for the decision and the budget. Second, the appointment of the professionals by the TMO, criteria, roles, interface between professionals. Third, the procurement of the design and build contractor, looking at the process adopted and compliance. Fourth, planning. Fifth, the cladding, particularly the design and selection decisions, compliance with ADB and industry guidance, consideration given to fire safety or fire risk, with a particular focus on the ACM panels, the rain screen insulation, the window infill panels, the windows and window surrounds, cavity barriers, and the crown. Sixthly, fire strategy, pre- and post-refurbishment, development and adequacy, including consideration of cladding. And seventh, building control, with the principal focus on the facade. So far as witnesses are concerned at Module 1, I start with Studio E. We'll begin by hearing witnesses from Studio E who were the architects who were originally retained by the TMO directly and subsequently became a subcontractor of Ryden once Ryden had become employed by the TMO as the design and build contractor, main contractor, in March 2014. Under the TMO appointment, Studio E were the lead consultant, lead designer and architect. Although no signed contract was ever concluded between the TMO and Studio E for the period prior to Ryden's appointment as the main contractor between them, the Studio E witnesses have accepted, it appears, that they worked on the basis that their contractual relationship was governed by the RIBA Standard Conditions of Appointment 2010 and Appendix B Schedule of Services. As to the period when Studio E worked for Ryden, a deed of appointment and a schedule of architectural services was eventually signed on the 3rd of February 2016, only a few months before the end of the refurbishment, together with a deed of collateral warranty in favour of the TMO. We will be hearing, as witnesses, from Mr. Kuchel, André Kuchel, who was a director of Studio E and one of its original founders, who was involved in the early stages of Studio E's involvement and in the design review process. We will hear from Mr. Bruce Soons, an architect associate at Studio E, who was the most senior professional architect involved in the day-to-day running of the Grenfell Tower project up to July 2014, supervising the work of Mr. Neil Crawford and Thomas Reck. We will hear from Neil Crawford, who answered to Bruce Soons and who had day-to-day involvement with the project from July 2014. And we will hear from Thomas Reck, who also answered to Bruce Soons and who worked on the project from September to December 2013 when he left Studio E. He assisted in sourcing some of the materials used in the cladding and other aspects of the design and specifying them in the NBS specification, which formed the basis of the tender in late 2013. Call participants will have seen from Studio E's written opening statement that they have prepared an appendix comprising a critique of Paul Hyatt's experts report. We have asked for sight of that document so that Mr. Hyatt could consider it, but it arrived with the inquiry too late to be considered before disclosure to call participants of Studio E's written statement, and we are still considering it. I next turn to Exover Warrington Fire, or Exover. Now, they were appointed by the TMO early on in the project, indeed in mid-2012, to provide fire safety engineering services. They were appointed under two separate instructions. The first instruction was to prepare a fire strategy for the building as it stood, the existing fire strategy. And that was because no fire strategy existed for Grenfell Tower at that time. The second instruction was to prepare a fire strategy in relation to the proposed refurbishment works. The fire strategy for the existing condition of the building was prepared by Kate Cooney, a principal consultant at Exova, and was dated the 16th of August 2012. As to the refurbishment fire strategy, Exova prepared 3 versions of that, the last of which was dated the 7th of November 2013. Exova's appointment predated Ryden's appointment as the design and build contractor. After Ryden's appointment, Exova did provide further advice to the building professionals on the project on an ad hoc basis, but Exova were not, it appears, engaged directly by Ryden. During Module 1, we will be hearing from 4 Exova witnesses, including Miss Cooney, who prepared the fire strategy for the existing building, and Mr. Terence Ashton, who prepared the fire strategy for the refurbishment works. We will be exploring with those witnesses the scope of services which Exova committed to provide on the project and whether that work was delivered as anticipated. We will be considering the fire strategies prepared by Exova and whether they were appropriate and reliable given the information which had been provided to Exova over time. We will also be considering the ad hoc advice provided by Exova during the project, including the extent to which that assists in understanding the state of knowledge of the professionals on the project about the likely fire performance of the external wall. I then turn to Ryden. Ryden were the TMO's main contractor on the Grenfell Tower project, having won an open tender on the 18th of March 2014 based on Studio E's NBS specification and the invitation to tender of the 29th of November 2013. They were engaged by the TMO under a conformed version of the JCT 2011 design and build contract, which incorporates specific amendments which were agreed to the standard JCT terms, which was executed on the 30th of October 2014. Ryden were performing before that date and had signed a pre-construction agreement on the 22nd of May 2014. Once Ryden was appointed, Studio E proceeded on the basis that it was a subcontractor of Ryden, although that was only formalised much later in February 2016 under the deed of appointment I referred to earlier, which had retrospective effect. There was also, as I say, a consultant deed of collateral warranty in respect of the Grenfell Tower project between Studio E, the TMO, and Ryden, dated the 25th of April 2016, under which Studio E warranted to the TMO, promised the TMO, that it had performed and would continue to perform all of its duties arising out of its subcontract with Ryden under the deed of appointment. We will be hearing from a series of Ryden employees who were involved in the project, and in particular Simon Lawrence, who was the contracts manager for the project for Ryden and who helped put the winning bid together, and who left Ryden in October 2015 before the end of the project. From Simon O'Connor, who was the project manager for the Grenfell Tower project between May 2014 and July 2015. David Hughes, who was the Ryden site manager from October 2015. And Stephen Blake, who was Ryden's refurbishment director, who took over the role of contract management when Simon Lawrence left Ryden in October 2015. I turn to Harley. Harley were Ryden's specialist subcontractor. They were in contact with Studio E in September 2013, long before Ryden were involved, and indeed before the invitation to tender. And at that stage, they were producing pricing information for Studio E for the cladding and its component products. They were also talking to the suppliers of ACM panels, Arconic. Harley's eventual contractual relationship was with Ryden and was governed by an undated letter of intent, but which includes a reference to a quotation dated the 11th of July 2014. The Harley letter of intent expressly incorporated a formal contract, the JCT DOM 2 Articles of Agreement and Subcontract Conditions 2011 as amended for the design of the facade works, and also certain Ryden standard terms and conditions which were attached as Appendix B to the letter of intent. The Harley witnesses will include Mr. Ray Bailey, the sole director of Harley Facades Limited, which was the successor company to Harley Curtain Wall Limited from September 2015, of which he had also been a sole director. Ben Bailey, son of Ray, who was the project manager on the Grenfell project from February to July 2015. Mark Harris, Harley's sales consultant, whose main role was securing Harley's involvement prior to Ryden retaining Harley under a subcontract, under the letter of intent, and who had a contact at Arconic, the ACM panel makers, namely Ms. Deborah French. Daniel Anketel-Jones, the designer manager at Harley, who was also involved with the Grenfell project between June 2014 and May 2015, and Mr. Kevin Lamb, an independently outsourced specialist cladding designer who produced the detailed design drawings for the external envelope of the tower. He is a core participant in his own right, and he has his own separate representation in this inquiry. He has filed a written opening statement, but he will not be making an oral opening statement to you. I next turn to CEP. CEP was responsible for the rain screen element of the cladding, which had to be fabricated into cassette panels. CEP carried out that task. They had been involved with the Grenfell Tower project since as early as March 2012, when discussions were had with Studio E. Now, CEP had a long-standing commercial relationship with Arconic. It became fully involved with the project in January 2014, when Harley asked CEP to quote for the cladding as part of Harley's tender to Ryden. In September 2014, CEP quoted for and agreed to supply the window frames for the refurbishment, and in February 2015, CEP quoted for and agreed to fabricate and supply the ACM cassette panels forming the rain screen using Arconic's Reynobond 55 polyethylene or PE core ACM sheets. CEP's supply contract was with Harley, but that was then novated or refreshed to Ryden in September 2015. Geoffrey Blades, who is CEP's commercial projects manager, will be giving evidence. I turn next to Max Fordham. Max Fordham was the building services engineering consultant retained throughout by the TMO to advise on energy strategy and sustainability, and in particular on the proposed improvements to the thermal performance of the building. Max Fordham was retained on standard ACE terms. It was Max Fordham that identified, in August 2012, Celetex's FR5000, a PIR product, as suitable insulation for use in the cladding system because it could both meet its target thermal performance value and was also thin enough to work within Studio E's proposed design dimensions. Celotex FR5000 was specified by Studio E in the NBS specification in November 2013, and Celotex RS5000, which according to Celotex was the same product, was supplied and put on the building as the main insulation product within the cladding structure. Max Fordham have chosen not to make an oral opening statement. Mr. Andrew McQuat will give oral evidence. I should mention John Rowan Partners. They were the clerk of works who were retained by the TMO, whose role included site inspection and monitoring. We will be hearing evidence from Jonathan White and Gurpal Verdi. Osborne Berry were retained as the building contractors by Harley and fitted the windows and the cladding system. We will be hearing evidence from Graham Berry and Mark Osborne about workmanship and inspections. Osborne Berry have filed a written opening statement for Module 1, but have chosen not to make an opening oral statement. SD Plastering Limited were another Ryden subcontractor who were responsible for the installation and making good of the window surrounds. We will be hearing evidence from Mark Dixon, a director of SD Plastering Limited. I next turn to RBKC's building control. RBKC's building control department inspected the site and signed off on the refurbishment work as compliant with the building regulations. As I said earlier, RBKC have, in their submissions or statement, accepted that building control failed to ask for comprehensive details of the cladding system, including the crown, failed to request an up-to-date version of the fire strategy for the refurbishment, failed to identify that the insulation materials or products used in the cladding system were not of limited combustibility, and therefore did not satisfy the requirements of paragraph 12.7 of approved document B. And they accept that building control should not have issued a completion certificate as it did on the 7th of July 2016. In Module 1, we will be hearing from two RBKC building control officers, namely John Hoban and John Allen. Artelia was the project CDM, or Construction Design and Management Coordinator, employer's agent and quantity surveyor, with its services that they were to give set out in various RICS standard form appointment documents. And RICS, Mr. Chairman, is the Royal Institute of Chartered Surveyors. Artelia was retained by the TMO throughout, from about April 2012, but formally contracted from August 2012. Its CDM coordinator role ended on the 5th of October 2015, when a new role of principal designer under the CDM Regulations 2015 was assumed by the TMO. We will be hearing from a number of Artelia witnesses, including Simon Cash, Philip Booth and Neil Reed. The TMO. Finally, we will be hearing from a number of witnesses from the TMO in this module about its role in the procurement and oversight of the project, the decisions it made and those it left to others. And our witnesses at the moment include Claire Williams, the full-time project manager for the TMO on the Grenfell Tower refurbishment, and Peter Madison, whose role was to provide strategic overview and the asset management aspects of the project. There are some others. So far, I have identified the main participants in the matters, the subject matter of Module 1, and from whom we will be calling factual evidence. In addition, we have had written opening statements from J.S. Wright. They were Ryden's M&E subcontractor, based on a letter of intent from Ryden of the 25th of July 2014. It had very little involvement in the issues the subject of Module 1. We do not propose to call any witnesses from J.S. Wright in Module 1. We will also, there are also involved Curtins Consulting. Curtins were retained by the TMO as the structural engineer for the refurbishment on an ACE form on about the 12th of February 2012, which was then novated or refreshed over to Ryden in January 2016. We do not propose to call any witnesses from Curtins Consulting in Module 1. J.S. Wright and Curtins Consulting have chosen to make no oral opening statements in Module 1. Finally, I should mention, Mr. Chairman, that the inquiry has received short written statements for Module 1 from the LFB, the FBU, the MHCLG and the Mayor. The MHCLG has chosen not to address you orally in opening this module. And we are not calling any witnesses from those core participants at this Module 1. Finally, Mr. Chairman, Module 1 experts. As I said earlier in my address, the inquiry has obtained experts' reports from Paul Hyatt, Dr. Barbara Lane and Beryl Menzies for Module 1. They will be called to be examined over 3 days in the last week of the Module 1 timetable, currently timetabled as the week commencing the 30th of March. That is all I was proposing to say by way of opening phase 2 and module 1 to you. We have a timetable for opening statements of core participants for the rest of this week, and the first of those to address you now will be Studio E next this morning, and the opening statements will end on Thursday with oral statements from representatives of the bereaved survivors and residents. Mr. Chairman.
Thank you very much indeed. Well, the next statement on our schedule is due to be given on behalf of Studio E Architects by, I think, Mr. Popat, Queen's Counsel. Is Mr. Popat? Good, thank you. I'm sorry, I have to ask you to make your way all the way over to the desk here so that you can address everybody and be seen for the purposes of the video recording. So thank you very much. Yes, Mr. Popat.
Thank you, sir. Mr. Chairman, Madam, today I appear before you as a representative of Studio E Architects Limited. I appear before you to deliver its opening statement at a public inquiry, inquiring into one of the most horrific, tragic incidents this country has seen in peacetime. A disaster in which 72 people lost their lives, and many, many more were injured, traumatised, or had their lives ruined by grief or changed forever by the devastating consequences of losing family members and close friends. And so by this opening statement, made after 123 days of hearings in the first phase, Studio E is speaking for the first time at this inquiry. And as such, the first thing it says and wants to say is how truly devastated it is that this terrible, terrible tragedy occurred. Exactly who and what caused the fire, the spread of the fire, and its shattering consequences is being and will continue to be discovered by this inquiry and other investigations. But this does not preclude the people who make up this small company, who felt close to the community for the many years they worked there, recording their deep and profound sorrow for the tragedy that befell the occupants of Grenfell Tower, all those involved in the rescue attempts following the fire, all their loved ones, and all others affected as circles of appalling consequences rippled outwards from the events of the 14th of June 2017. So this disaster will haunt everyone involved in this project to refurbish the tower. And in this phase, and particularly by Module 1, it is the inquiry's role to question their actions. And Studio E will do its best to answer the questions asked of it. And it wholly supports the need for a thorough and wide-ranging investigation. But I must make it clear, and all the people involved with this company want to make it plain, that they have asked themselves searching questions since that fateful night in June 2017, and sought to examine what they did and whether they might have done anything differently which could have resulted in a different outcome. And this anguish will continue long after the questions posed by this inquiry or any other investigations. So what I propose to do next over the course of this opening is to provide a brief summary by way of answers to 3 questions. Who is Studio E? What part has it played in this inquiry to date, and what part will it play for the foreseeable future? And finally, the majority of my time will be spent summarising the answer to the question, what role did it play in the refurbishment project? I understand the timetable allocated, I think, 1.5 hours for this opening. I intend to take up about a third of that time, and I think we have notified the inquiry team.
Yes, I've been told that you think you'll need about half an hour, is that right?
Yes, sir.
Yes, thank you very much.
So let me turn to the first question and give a short introduction to Studio E. It is a corporate core participant at this inquiry, But the corporate description, whilst obviously legally correct, may give the impression of some large, faceless commercial organisation with layers of management and teams of employees. And if it does give that description, then that description would be utterly misleading in the case of Studio E. It is a close-knit company, founded in 1994, originally with 3 directors, 2 of whom still remain as directors more than 25 years on. At its height in 2008, it employed up to 45 staff, but by 2014, the year it was appointed on this project by Ryden, its staff numbers had reduced by 4/5, so that it had only 9 employees. It is always practiced from premises in London, though its work has spread across the country and abroad. The core of the practice's work has rotated around education, sports and leisure, recreation and commercial work, with a particular focus on designing environmentally sensitive buildings. It has punched above its weight in many ways and has regularly been recognised within the industry for its work. That recognition has included the Queen's Award for Sustainable Development, multiple awards from the Royal Institute of British Architects and numerous other awards. It has also always sought to approach its work with integrity and a social conscience. It has engaged with the local community wherever it has worked, for example through career talks at schools and taking numerous students for work experience. Now, I mention these matters not to seek to garner praise for Studio E, but to explain that it regards engagement with the environment and with the local communities in which it works as central to its existence and way of working. In short, it is and always has been a conscientious, ethical and responsible architectural practice. So with that, I move to the next question of Studio E's involvement with the inquiry. Its participation in the inquiry to date has been against a background of limited financial resources. The limit has been such that Studio E has had to make difficult decisions as to how best to deploy those resources. As a result, it was not legally represented for the Phase 1 hearings of the inquiry, and, following this brief opening statement, will not be legally represented during the Phase 2 hearings either. Absolutely no discourtesy is intended by the absence of legal representation. It is, I'm afraid, just a necessary consequence of the financial limitations placed upon the company. Now, I know at earlier points in the inquiry, comment has been made by certain of those involved that Studio E was choosing not to be involved in this investigation, or was not concerned to help the inquiry. The Studio E did not appear before you and didn't have teams of lawyers speaking on its behalf at public hearings. Such commentary was perfectly understandable. However, I do want to try and reassure everyone that nothing could be further from the truth. The people in this company have been extremely concerned at all stages of these investigations to try and assist your inquiries and to be seen to be doing so. It wants to engage, it is in its interests to engage, and it doesn't want to give the impression to anyone, least of all the bereaved survivors and residents, that it doesn't care, or that it's hiding away, or that it doesn't want to help. It may not be known or evident to everyone in this room, but sir, as you know, as requested by the inquiry, Studio E has disclosed substantial numbers of relevant documents from its project file. It has prepared and provided comprehensive Rule 9 witness statements totalling some 340 pages, setting out in detail its involvement in the refurbishment works. It has also now prepared a substantial written opening submission and appendix of over more than 80 pages. And 4 members of the practice, as you've heard, a director, 2 associates and 1 previous employee are attending to give oral evidence at this phase of the inquiry. The decision to provide such detailed documents and to take as open and cooperative approach as possible was in order to best assist the inquiry in understanding Studio E's involvement in the refurbishment works. This in turn, it is hoped, should assist the inquiry in discharging its terms of reference. Above all, everyone at Studio E, just like I expect everyone in this room, wants to help the inquiry to discharge its function, to identify any and all lessons that need to be learned, and to identify and make the changes that need to be made, so that when buildings are constructed or refurbished in the future, the risk of a disaster like this ever happening again are eliminated. So let me turn now over the next 15 minutes or so to my third question, and briefly to explain Studio E's involvement in the project. Now, the detail of this involvement is set out in the many pages of witness statements and Studio E's opening, which I've already mentioned, which I understand will be published in due course. But before developing this account, and hopefully to assist orientation through it, let me just set out a few points that were listed at the beginning of Studio E's written opening statement. This is in order to summarise its considered position on matters relevant to this phase of the inquiry. First, having retrospectively examined and considered it, Studio E does believe that the relevant regulatory system was not fit for purpose and appears to have permitted the routine use of unsafe cladding materials on buildings for many years. Product manufacturers produced materials and testing data which had the effect of misleading designers to consider that their products were safe. Third, at the time of the project, Studio E did not have any knowledge that the products used on the tower were unsafe, and there was no information available to it, or, as it understands, to other architects and designers which would have reasonably alerted it to any lack of safety. And fourth, whilst it will continue to examine this question and will listen to, and where it should, it will accept any criticisms levelled against it, from its understanding of the industry and awareness of the volume of tall buildings at the time with materially similar external surfaces, Studio E does consider that it acted as would be expected of a reasonably competent architect in its position. So this summary is necessarily a preliminary analysis. I must stress it is not an attempt to prejudge the evidence to come. It is not an attempt to pass the buck. Studio E will listen carefully, and its understanding, like everyone else's, will deliver over the coming days and weeks. As an organisation, and most importantly as human beings within that organisation, everyone associated with this company wants to understand and learn, however painful that might be. I must also make it clear that this summary and what's in the written opening is based on the evidence that Studio E has to date been able to consider. The truth is that due to the funding restrictions, Studio E has not been able to consider with its advisors all evidence disclosed by the inquiry or by the other core participants. It and they have focused on the materials that it's anticipated will relate most to Studio E's role on this project. That has included the report of the inquiry's appointed expert architect, Mr. Paul Hyatt. Mr. Hyatt's report is over 500 pages, and Studio E's preliminary analysis has identified numerous what it regards as technical or factual inaccuracies in key regards. Further, Studio E does disagree with many of the opinions expressed by Mr. Hyatt in that report. In order to assist hopefully everyone who has to consider this question, and the time that has been limited and afforded to Studio E since the disclosure of that report, it has responded to that report by way of an opening statement which sets out a detailed but not exhaustive appendix setting out its concerns and where it considers these inaccuracies may impact on the inquiry's ability to comply with its terms of reference. Studio E understands that that appendix will be published certainly in due course. And so I've said all of this by way of summary because it is set out in the written opening statement of Studio E. However, I make clear that I have carefully listened to Mr. Millett's opening statement, and particularly his admonishment of the corporate call participants for not making admissions and identifying their own failings. Mr. Millett urged all involved to consider carefully their positions and all witnesses to give truthful, full evidence. Sir, I assure you, as I've already said, that Studio E will continue to give that careful consideration. And, as I've already said, it will recognise and accept criticisms levelled against it where it is appropriate to do so. And I assure you that its witnesses intend and want to give as much assistance as possible to the inquiry through their evidence. And there is no question at all but that they will give truthful accounts of their involvement throughout this project. So let me turn to the chronology of Studio E's involvement in the project, and I'll begin with its appointment. But in giving this chronology, I am aware that the Counsel to the Inquiry has provided a short summary of that of its own this morning. But starting with the appointment, Studio E's involvement arose from its work in 2011 on the Kensington Academy and Leisure Centre on the site next to Grenfell Tower. Studio E had been appointed on the Academy project following an open tender process, and during the course of those works, the Royal Borough of Kensington and Chelsea informed Studio E of its intention to refurbish Grenfell Tower. The Council introduced Studio E to the Kensington and Chelsea Tenant Management Organisation, or the TMO, and the Council and the TMO indicated their intention to maximise the potential benefits from appointing the team from the Academy project on to the Grenfell Tower project. In early 2012, the TMO provided Studio E with a brief for the Tower project, which included addressing poor energy efficiency in the tower by, amongst other things, replacing the existing windows to the flats and overcladding the tower. Following this, Studio E assisted the TMO in contacting the team involved in the KLC project for the works to Grenfell Tower, and this included the fire consultant Exova. This arose from the initial meeting with the TMO, where Studio E raised its view that specialist fire safety advice may be required on the project. This recommendation was accepted by the TMO, and Studio E was instructed to approach Exova to provide a quote for the provision of specialist fire consultancy services. And the TMO subsequently engaged Exova as its fire engineer. The TMO's agent, Artilia, was responsible for coordinating the appointment process on the TMO's behalf. Having explained that initial involvement, let me turn to the project planning, which was the next stage in the project. During the early part of the project, Studio E's work mainly included preparing the application for planning permission. A priority for the envelope at this stage was to agree the appearance of the tower with all stakeholders and the planning authority. This took the form of extensive discussions over an extended period of time involving the planning authority, the TMO, local councillors, Studio E and other consultants. In selecting the materials to be proposed in the planning application and to ensure that all relevant considerations were identified, Studio E engaged with numerous consultants, including Exova and different suppliers. While various issues were raised, which were then considered and resolved, such as costs, durability, method of installation, procurement factors and the like, none of these consultants or suppliers raised any queries or concerns regarding the brief to overclad the tower or the compliance of the cladding and its components with the building regulations. In fact, Studio E was directed to other high-rise residential buildings using similar materials to those under consideration for the tower. And during this time, the TMO was in negotiations with Leadbitter, who was the contractor on the KLC project, regarding its involvement in the refurbishment works. The negotiations were unsuccessful, and following its initial involvement in the project, Leadbitter fell away. thereby depriving the project team of early contractor advice and indeed causing significant delay. Once it became clear that Leadbitter was not going to be appointed, the TMO took the decision to put the project out to tender on a design and build basis and instructed Studio E and the rest of the design team to prepare the tender documents. And that's the next stage of the chronology that I address. It relates to the preparation of the employer's requirements, which form an important part of the tender documents. The employer's requirements provide a description of what the employer, in this case the TMO, is looking to achieve on the project, including the specification for the building, the scope of services required from the contractor, and an allocation of risk for unknown items. The employer's requirements are not a completed design. The detailed design was expressly envisaged to be developed once a contractor was appointed. Studio E prepared its contribution to the employer's requirement, and other members of the design team were responsible for preparing drawings, specifications and schedules relating to their design packages. For example, mechanical electrical engineering was done by Max Fordham, structural engineering by Curtains, fire safety engineering by Exova, landscaping by Churchman and others too. As part of this, for instance, Max Fordham advised on the thermal performance of the building envelope and proposed the use of Celotex FR 5000 for the rain screen cladding insulation. To the extent the packages had interfaces with each other, Studio E considered that it did have a coordination role. During the preparation of the employer's requirements, Studio E engaged with a number of manufacturers, fabricators and installers, including Harley, in addition to collaborating with the other consultants. Studio E provided each entity with what it regarded as sufficient details to identify the necessary requirements for the tower, including elevation drawings, and some were invited to site. From such inquiry, it would have been self-evident to any manufacturer, fabricator and/or installer that its products would need to comply with the relevant regulatory regime. Again, none of the entities contacted by Studio E raised any queries or concerns regarding the brief to overclad the tower or the compliance of the cladding and its components with the building regulations. Indeed, and again, it was pointed out to Studio E that other high-rise residential buildings use similar materials to those under consideration for the tower. Studio E relied on the advice of the appointed consultants and the suppliers and specialists that it consulted that the products being considered were suitable for the intended purpose. And it does consider that it was reasonable and appropriate for it to do so. Had any specialist raised any concerns or even queries, its conduct on the project demonstrates that it would have acted upon them. Save for some limited queries which were set out in the Studio E Rule 9 witness statements, neither Exova nor Building Control raised any queries or concerns regarding that brief, or with compliance of the cladding with the building regulations. Indeed, the advice provided by Exova in its fire strategy report regarding compliance with Part B4 of the building regulations was that the proposed changes, that is the overcladding proposals, will have no adverse effect on the building in relation to external fire spread. And that this would be confirmed in a future issue of the report, though no future issue of the report was provided. The project was a design and build procurement, and the products and materials referred to in the employer's requirements were not prescriptive. The eventually successful contractor, Ryden, and its specialist subcontractors had discretion to propose alternative products and materials. And it was contractually responsible for the entire project, including the design of all aspects. I'll turn to that again just in a moment. The employer's requirements expressly required that the tendering contractors would carry out detailed design of the rain screen cladding system, and therefore had discretion as to how to carry out that design and to propose alternative materials to those referred to in the specification. The requirements also require that any materials complied with specified performance standard. As I say, having mentioned Rydon, let me turn next in the chronology to its appointment as the design and build contractor. Rydon held itself out as having a speciality in refurbishing affordable housing, including high-rise residential towers. Upon appointment, Rydon took on design responsibility for the project, and that is an important point that is sometimes overlooked. Rydon was responsible for developing the design and specification contained in the employer's requirements into something that could be built. Rydon appointed various specialist subcontractors who were responsible for the design of their package of works on the project, such as the M&E Engineering subcontractors J.S. Wright and Company Limited, and the cladding subcontractors Harley. Harley was particularly experienced in high-rise residential refurbishments, and Studio E understood had worked with Rydon before, such as on the Chalcots Estate and Fairhoe Point projects, which used, it was understood, similar cladding to that used on this project. Studio E was appointed by Rydon to provide architectural services during the construction stage of the project. A significant proportion of Studio E's time post-contract was spent on the 4 mixed-use floors below the 20 residential floors, which Studio E understands aren't relevant to the inquiry's investigation. Now, at this time, in around April 2014, Studio E's operation as a partnership under the name Studio E LLP ceased trading, and Studio E Architects Limited took over the works. The change in entity had no connection to the works at the tower and did not lead to any changes to the staff on the project. When Rydon appointed Studio E, it confirmed that it tended not to use architects to the extent that other contractors might do. Rydon envisaged Studio E's role being more responsive, with Rydon maintaining a greater degree of control over the design process than Studio E would normally expect from a design and build contractor. Its appointment with Rydon was only formalised towards the end of the project. Harley was Rydon's specialist subcontractor, to which Studio E understands Rydon had delegated its design responsibility for the cladding facade. Studio E's role included providing comments on Harley's developing detailed design drawings from the perspective of the architectural intent. This included aspects such as siting, spatial arrangements, amenity, tolerances, dimensional coordination, appearance, proportions, colours or finishes of the products. Studio E did not consider that the review of these drawings was to check that they were technically correct or necessarily compliant with building regulations. The subcontract package for which Harley was responsible was specialist in nature. The Studio E was not responsible for identifying technical errors in the designs and or specifications of these specialist disciplines. It was for Rydon and its specialist subcontractors to determine whether the materials proposed for the cladding and its fixtures were suitable and met the relevant requirements, as set out in the employer's requirements. Studio E, though, was responsible for coordinating the building controls approvals process and coordinating between building control and the relevant entities to resolve queries to building control's satisfaction. Studio E carried this out in accordance with building control's specific requirements and resolved this to their satisfaction. Studio E also now understands that there was direct contact with building control and other parties on the project that did not involve Studio E. Of course, building control ultimately certified the works as compliant. Studio E does consider that it is of central importance to the inquiry's investigations that building control departments or approved inspectors across the country have certified similar buildings. According to the MHCLG's update of 14th of November 2019, 436 other buildings above 18 metres have been reported as being clad in aluminium composite materials. Studio E understands that this figure does not include buildings with materials with similar properties to ACM. This appears to demonstrate a systemic issue which has had repercussions across every area of the construction industry. For the many residents that find themselves in buildings which are now considered to be unsafe, and of course for those connected to the tragedy of Grenfell Tower. The Studio E wholly supports the inquiry's investigations and hopes that these investigations establish why so many professionals and building control departments across the country considered these materials to be suitable for use on buildings of this kind prior to June 2017. So it's hoped that this broad summary is of some assistance to the inquiry and to those who are not familiar with the background to the project. As this inquiry progresses, it will be necessary to examine the detail of these events, and it's very much hoped that the Rule 9 statements and the detailed opening will assist in this regard. So that completes all I wish to say by way of opening statement. I conclude by expressing once again the heartfelt condolences and sympathies of all those associated with Studio E, and also repeat, as I am instructed to, that each person associated with Studio E who will give evidence to this inquiry in the coming days wants to assist the inquiry to the absolute best of their ability. It wants to work with you and the inquiry team to achieve the stated aims of this phase, to examine the circumstances and causes of the disaster, including how Grenfell Tower came to be in the condition which allowed the fire to spread in the way it did. And I assure you that is what it will seek to achieve at every stage. So I thank you, and those are my submissions.
Well, thank you very much, Mr. Poppet. Well, that might be a convenient point for us all to have a break. We're running slightly ahead of ourselves, so I'm going to suggest that we break now and resume at 11:45, and then we shall hear from the representative of Ryden.
Ryden's next. I don't know. Yes.
Yes?
Yes.
Right, 11:45 then, please. Good. Well, now the next statement is going to be made, I think, by Mr. Taverner on behalf of Ryden. Mr. Taverner, are you? Good. I'm sorry that all of you have a rather long walk to get to the desk, but we can't do much about that, I'm afraid. Yes, Mr. Taverner.
Good morning, Madam. Good morning, Mr. Chairman. I appear on behalf of the company, Ryden Maintenance Limited, and I'm instructed on behalf and by Mr. Nick Young of DACB Solicitors. I will refer to the company as Ryden. Ryden's employees, past and present, 21 or so in number, have engaged separate lawyers, Pinsent Masons and TLT. As the inquiry embarks on phase 2, the repeated condolences and sympathies expressed by all those connected with the refurbishment of Grenfell Tower might seem hollow to the bereaved survivors and relatives. No one, however, including those of us who have visited the tower since the fire, could feel anything other than deep sorrow and profound regret at the circumstances which resulted in such a dreadful tragedy. Ryden and its representatives repeats its sincere condolences and will continue to assist the inquiry as fully as it is able. The ramifications of the disaster continue to haunt Ryden and their employees and will do so for the rest of their lives. I can assure all absolutely that Ryden is committed to assisting the inquiry in finding the truth. As to the assistance so far given to the inquiry by Ryden, it has disclosed over 91,000 documents. It has provided 2 Rule 9 statements dated the 23rd of November 2018 and the 5th of March 2019, and the first of which is over 240 pages long. During phase 1, Ryden produced a position statement dated the 9th of February 2018 and a written opening and closing dated the 15th of May 2018 and the 6th of December 2018 respectively. Ryden has produced a 47-page written opening for this phase 2 module 1, and that can be found at relativity RYD 000 94360. Ryden's employees have provided the inquiry with statements between the 5th of September 2018 and the 14th of November 2019. 15 of those have been released by the inquiry to date. The inquiry is due to hear from 8 of those individuals in the course of Module 1. Finally, we responded to the invitation from the inquiry to propose questions which the Inquiry Council may wish to explore with witnesses. Turning now, if I may, to this oral opening, obviously it would be of no great assistance to the inquiry simply to repeat our written submissions. And in broad terms, what I intend to do is make some preliminary observations and then briefly highlight certain aspects of our written opening. And I estimate that I will be finished well within an hour. I make 3 preliminary observations, if I may. The first involves comments in the written openings of some core participants that the employees' witness statements do not deal either at all or in sufficient detail with all of the criticisms levelled against it. May I say, in part response at least, that those statements were prepared before the inquiry expert reports were released in October of 31st, or on the 31st of October of last year. It is in these reports, and in particular that of Mr. Hyatt, the inquiry's architectural expert, that specific criticisms of Ryden emerge. The witness statements were prepared well before notice of other matters raised by other core participants in their openings released just 10 or so days ago. How matters unfold during the course of questioning of all witnesses of fact assisting the inquiry, and how the inquiry experts respond to issues raised by certain core participants with regard to their report, all remain to be seen. It is depressingly clear from the core participants' written openings that there are differences, certainly as to the perceptions, as to how certain decisions were made. It's also clear that many core participants do not accept, to varying degrees, the reasoning or conclusions of the inquiry's experts. For all these reasons, together with the fact that important documents are still being released and assimilated, we have concluded that it is not helpful in the course of an opening such as this to either predict or assume what will emerge from the evidence during the course of the forthcoming months, or indeed to argue a position. Ryden, and indeed all parties, as suggested, will be in a much better position to assist the inquiry in its closing submissions, scheduled for October of this year. This approach may also have the added advantage of the inquiry having all of Ryden's submissions on modules 1 to 3 all in one place, rather than to have them collated from one particular source. But of course, on that matter, Ryden will be guided and governed by the inquiry. My second observation relates to the order in which the inquiry is hearing the witnesses of fact. Ryden notes that the first 5 Module 1 key issues are set out chronologically. Those issues start, as outlined by Mr. Millett this morning, with the decision to refurbish before then moving through the procurement and planning stages, to then the consideration, the important consideration, of the design and selection of relevant products and their compliance with regulatory, ADB and industry standards. Briefly, in setting the context of and for the chronology, firstly, Ryden only had a peripheral involvement until the publication of the official Journal of the European Union notice and the pre-qualification questionnaire process in September of 2013. Ryden featured more prominently following the invitation to tender in November 2013, and Ryden was informed in early March of 2014 by TMO that its bid had been successful. Ryden and TMO subsequently entered into an amended design and build contract signed on the 30th of October 2014. And of course, we know that practical completion of the refurbishment works was certified as being the 4th of July 2016, less than a year before the tragedy. Ryden's significant involvement in the project, therefore, came after the decisions to refurbish, the decisions made as to the procurement routes, and further the initial appointments, at least, of many of the professionals involved at Grenfell Tower. Ryden's involvement, therefore, postdated by some time the involvement of many of the core participants, including RBKC and TMO, and also Artilia, Studio E, CEP, Exova, Max Fordham and Harley. Notwithstanding it is right that some important design decisions were made subsequently, by the time of Ryden's appointment, significant decisions relating to the refurbishment works had been made, which led to what has been described by some as a more prescriptive employer's requirements, as opposed to a more performance-based specification being put out to tender. We understand, of course, the impossibility of calling witnesses to reflect a strict chronology relating to what decisions were made, by whom, and, all importantly, why. All are integral to the exploration of the Module 1 key issues, and there are many strands. We simply observe at this stage that Ryden's personnel are due to be called earlier on in the process and before many of those who will be giving evidence as to how preceding decisions were taken. My third and final preliminary observation starts by noting that Module 1 and Key Issue 5 in particular is formulated as follows, and I hope, Mr. Chairman, you'll forgive me for reading it out. The cladding, design selection decisions, compliance, ADB/industry standards, guidance, consideration given to fire safety risk with particular focus on A, ACM panels, B, rain screen insulation. The Key Issue 5 then goes on to list other aspects of focus. The ACM panels installed at Grenfell as part of the cladding system was, of course, Arconic's Rainabond PE, polyethylene. The rain screen insulation used was Celotex RS 5000. Decisions relating to those products were clearly informed by assumptions made by some core participants as to the characteristics of Rainabond PE and Celotex RS 5000, and their understanding, right or wrong, of the meaning of the building regulations and in particular approved document guidance. How those products were perceived by those involved in the refurbishment at Grenfell cannot, we respectfully suggest, be divorced from the manufacturer's claims about the characteristics and properties of those products and what Arconic and Celotex, the company, wanted the marketplace to believe when making those claims. There will, therefore, in our submission, inevitably be an overlap between the investigations being carried out during the course of the evidence in Module 1 and those matters to be considered in Module 2. The fact of this overlap is in fact reflected in many of the parties' written opening submissions for Module 1, and the fact that, of course, Arconic and Celotex have both given written opening submissions and will be heard in the course of this week orally. I turn now, if I may, to address more substantive issues, and I do so in the following order. First, the position of Ryden. Second, the position of Studio E and Harley. And thirdly, the role of Arconic and Celotex in the design selection decisions and the consideration given by them to fire safety risk. I turn first to Ryden, and it's understandable that the focus first falls on Ryden, it being the design and build contractor. Ryden was first invited to tender, as I have said, in September of 2013. It was effectively engaged in March of 2014 and formally contracted by TMO in October of 2014. It is accepted by Ryden that it took on express and implicit contractual obligations relating to the quality and standards of the design and construction of the refurbishment works. Properly performing those qualitative obligations, as is usual in a design and build context, required Ryden accessing the skills and specialist knowledge from many diverse disciplines. On the design side and relating to the cladding in particular, Ryden needed to engage architectural and engineering know-how and also expertise from specialist subcontractors. Those particular professional skills were not expected to be held in-house by a company such as Ryden. It is commonplace, as happened in this case, for a design and build contractor to delegate tasks by way of consultant engagements and specialist subcontracts. Notwithstanding that delegation, it is acknowledged that Ryden still retained a contractual responsibility for the performance of those parties to whom it delegated those or indeed any tasks. It is important that we emphasise, however, that delegation in this way should not be viewed as being in any way unusual or atypical in approach. Also typical in this approach is that a design and build contractor will inherit and take on the professionals already involved in the project, being those whom have progressed the design to the stage where it is sufficiently developed for the employer to feel comfortable with what is then to be tendered. And there's a good technical reason for that. It gives rise to project-specific continuity in the design process, which should, if the process works properly, reduce the risk of errors or omissions in that design. This taking on of the existing professional team is often done by way of what is called novation, the professional's engagement being transferred in effect from the employer to the design and build contractor. In this case, it was not strictly a novation. Ryden engaged Studio E on specific and all-embracing terms. There's no suggestion from Mr. Hyatt, the inquiry's architectural expert, or indeed, as we understand it, any of the other inquiry experts, that Ryden should be criticised for continuing with or engaging either Studio E as architects or using Harley as specialist cladding package subcontractors in seeking to fulfil Ryden's contractual duties. Indeed, Mr. Hyatt explores in his report and comes to the conclusion, it appears, that Studio E had a respectable reputation and they appeared to have all the necessary architectural, design and technical, as well as organisational and management skills to be needed and required to undertake the project. Both Studio E and Harley, the latter on an uncontracted basis, had been involved earlier in the process than Ryden and had been trusted by TMO and RBKC. Like Ryden, Studio E's contracts of engagement and Harley's subcontract defined the scope of their obligations. It defined their tasks and the standards by which each of Studio E, Harley and Ryden should be judged in determining whether they carried out those tasks properly. Exploring what was delegated to whom and on what basis as an important part, we respectfully submit of the fact-finding process. By referring to those matters, Ryden is seeking to explain what it did and why it did it. Apart from their contractual obligations, Ryden also acknowledges here that as a result of what Ryden and its employers actually did in seeking to perform its duties under its contract with TMO, it assumed certain duties of care to third parties to its contract, and in particular to the occupants of Grenfell Tower. Although it is not the job of the inquiry to determine civil liability, Ryden and indeed any other party's legal responsibility to third parties to the contract, and indeed moral culpability, must, we respectfully suggest, be considered in the light of the obligations that any particular party took on under their respective contracts, and in what that party did or did not do in order to discharge those obligations. That includes, from Ryden's position, what it considers was the reasonable delegation of certain tasks to parties such as Studio E and Harley. What tasks were delegated and whether it was reasonable by the standards then operating at the time to do so is a matter which will, it is anticipated, be considered carefully by the inquiry. We note that there appears to be an issue, a factual issue, as to what extent, if at all, Ryden in fact required less of Studio E than the agreed services set out in its terms of engagement. Those matters, and in particular whether the task of considering compliance with the building regulations of the cladding system was in any way diluted, will need to be considered by the inquiry in its exploration of the evidence. In all of this, and when dealing with standards, I hope it's not too simplistic to say that the skills and standards and experience of a professionally qualified architect are not necessarily the same as those held by a specialist cladding subcontractor or indeed an experienced design and build contractor. Can I first turn now to look at Studio E and what tasks were delegated to Studio E? We know, and has been outlined already this morning, Studio E had been engaged in the first instance by TMO. There's a lack of clarity as to the terms, but it appears to have included incorporation of the RIBA standard conditions of appointment for a consultant 2010. Those RIBA standards required only materials which complied with the building regulations to be specified. Studio E was subsequently engaged by Ryden. The terms of that engagement are set out in the deed executed on the 3rd of February 2016, retrospective in effect and signed by Studio E. Those terms of engagement can be found as, on the relativity system at SEA 000-14274 _ 0003. Those terms of engagement included a schedule of architectural services which Studio E agreed to provide. That particular document can be found at the same reference but _ 0011. Those particular services included, and there are many that are material, but for present purposes they included paragraph 7. The services allocated to Studio E were, and I quote, responsibility for coordinating building regulation approval for and on behalf of the contractor of course being Ryden. And importantly at paragraph 8, to seek to ensure that all designs comply with statutory requirements, including scheme development standards. Statutory requirements includes the building regulations. At paragraph 13 of the services, Studio E was required to coordinate any design work done by consultants, specialist subcontractors and suppliers. And paragraph 15, to liaise with various statutory bodies as required, including fire authorities. And finally, by paragraph 17, to examine subcontractors and suppliers' drawings and details with particular reference to, and I quote, performance criteria. Mr. Hyatt, we respectfully suggest, rightly identifies that the responsibility for ensuring that materials specified in the NBS specification, which form part of the invitation to tender and ultimately part of the contract, complied with the relevant building regulation and statutory guidance. None of the tasks delegated to Studio E was in any way unusual by industry norms and practices operating at the time. Turning now briefly to Harley, they were specifically engaged as the envelope package subcontractor by Ryden. They installed the cladding system, including Rainabond PE, Celotex and the fire barriers. There is no issue that a letter of intent under cover of an email dated the 25th of July 2014 governed Harley's appointment by Ryden, which described the authorised works, and again I quote, design of the facade works. The reference there, relativity, is HAR 000-10057 _ 0001. At paragraph 35 of our written opening submissions, we say this: as Harley witnesses acknowledge, it is normal practice for the facade contractor to consider compliance with the building regulations. Indeed, we say Harley was, pursuant to clause 2.1.1 of the terms and conditions, those are the terms and conditions of the DOM 2 JCT 2011 standard form, pursuant to that clause, required to ensure that its work complied with the building regulations. It's also to be noted, and it was this morning by Mr. Millett, and it reflects the importance of the roles of Studio E and Harley, that both those parties, and again, as is not uncommon, entered into a collateral contractual relationship with TMO through warranties which were dated the 25th of April 2016. In short, both Studio E and Harley undertook to TMO directly that they had or would comply with the duties that they had taken on under the terms of the engagement and contracts that they had entered into with Harley. Having considered briefly Studio E and Harley, I should pause here just to make one particular point, if I may. And it's one point of particular confusion. It is incorrect to conflate the concept of a contractual responsibility, which Ryden undoubtedly held, to carry out a particular task to a particular standard, and the actual carrying out of that task. At some stage during core participants' written opening submissions, it has been said that, and I quote, Studio E, Ryden and Harley designed the cladding system, unquote. It's absolutely right that Ryden took on a contractual liability under the contract with TMO relating to the design of the contractual system. That is not disputed. It is not right, with respect, to suggest that Ryden in fact designed the cladding system. What they did do, we submit, was properly and fairly delegate those tasks to others who held themselves out as having the appropriate skills to do so. It is an important and fundamental distinction. We also say that proper delegation of responsibility cannot be fairly characterised as abrogating responsibility. I mentioned briefly here Exova, the fire specialist. Exova is criticised at some length in the reports of the inquiry experts. We note in particular the reports of Dr. Lane and Mr. Hyatt. The chronology relating to Exova's involvement is long, and much of it predates the involvement of Ryden. Again, what they were asked to do, and by whom, and what they actually did, will become clear over the following weeks and months of the inquiry. Ryden did not contract with Exova, but are criticised for not appointing them or another fire specialist after Ryden came on board. Again, those particular matters must be explored with the witnesses, but at this juncture we only seek to highlight that it was never suggested to Ryden by Studio E or Harley that they needed further input from Exova to enable the safe completion of the refurbishment project at Grenfell. Consideration may also have to be given as to how, if at all, events would have materially altered had Exova been more involved. I turn finally to consider Arconic and Celotex, both of whom have put in openings to Module 1 and are due to make oral openings in the coming days. I do so, if I may, in the context of some comments with regard to the building regulations. At paragraph 20.1, page 47 of its opening submissions, the BSR number 1 team says this: ADB is fundamentally not fit for purpose and central government has been aware of that since 2000. This is plainly right. It is a theme which has been picked up by many in the industry with a degree of unanimity. For example, we note that in Studio E's written submissions, it references the RIBA submissions to the call for evidence by the independent review of building regulation and fire safety, and its response to the Dame Judith Hackett interim report. There is, however, and respectfully, a tension between this recognition and the criticism that Ryden ought to have been aware or brought to the attention of its professional consultants and its specialist subcontractors employed for the purpose of ensuring compliance with the building regulations, that the specification of Rainabond and Celotex was contrary to ADP and thus the building regulations. What is clear, however, is that Rainabond and Celotex RS 5000 were, with such tragic and catastrophic consequences, specified as part of the design of the cladding system. Studio E says at paragraph 12.17, this is page 29 of its written opening, that Studio E relied on the advice of appointed specialists and suppliers that the products that were being considered were suitable for their intended purpose. Without trespassing too much on Module 2 matters, and I do so briefly, I hope, I do ask for the following matters to be borne in mind when considering the evidence of the Module 1 witnesses as to how and why decisions were made. And the first relates to the rain screen cladding. It's often been repeated, and rightly so, that the inquiry concluded in the Phase 1 report that the principal reason why the flames spread so rapidly down and around the building was the presence of the aluminium composite material, the ACM. Rain screen panels with polyethylene cores, which acted as a source of fuel. Decisions were taken during the Grenfell project that ACM would be used and it would be Rainabond PE in cassette as opposed to riveted form. Ryden was of course aware of those decisions and approval for their use was in effect ultimately given by building control. I do point out this, that this is an employee of Arconic, and his name is Mr. Wehrle, spelled W-E-H-R-L-E. Arconic's Mr. Wehrle states at paragraph 63 of his September 2019 witness statement that he believes that cassettes perform more poorly than riveted panels because when the polyethylene core melts due to the heat of the fire, it tends to pool at the bottom of the cassette until it reaches the point of auto-ignition and flashes over. The reference for that is MET 000053105. With that in mind, it's right to note that a British Board of Agreement, or BBA certificate, was issued on the 14th of January 2008, which certified Rainabond PE. It was the only BBA certificate ever issued with regards to Rainabond PE, and the certificate did not distinguish between Rainabond PE in cassette or in riveted form. The BBA certificate can be found at ARC 50/678_0001. On the face of the certificate, it states as follows: behaviour in relation to fire. In relation to the building regulations for reaction to fire, the panels may be regarded as having a Class 0 surface in England and Wales and a low-risk material in Scotland. Under technical specification, section 1 of the certificate, at page 3, on underscore 0003, it says as follows. The panels are available either plain-edged, riveted system, or flanged, cassette system, to suit architectural requirements. The certificate states that section 6.1, and the only part of the certificate deals with a non-FR or fire-resistant panel, that a standard sample of the product with a grey-green Duragloss 5000 coating, when tested for reaction to fire, achieved a classification of B/S2 DO in accordance with EN 13501-1:2002. Classification B is a European classification. No distinction is drawn here, or indeed anywhere else in the certificate, between the riveted and cassette forms of the Rainer Bond PE panels. And finally, at section 6.3 of the certificate, as a consequence of 6.1 and 6.2, 6.2 deals with the FR version of the panels, as a consequence of section 6.1 and 6.2, the products may be regarded as having a class 0 surface in relation to the approved document B of the Building Regulations 2000. This final statement, nor anywhere in the certificate, distinguishes between the fire-resistant and polyethylene grades of Rainer Bond in their riveted or, to contrast, cassette forms. The BBA certificate is an important document as it is intended to be and is relied upon by construction professionals, as it was in the case of the Grenfell Tower refurbishment project, to contain accurate statements and information. A copy of this 2008 BBA certificate was sent to Harley and CEP, CEP being Harley's subcontractor, by Arconic's representative in the UK on the 23rd of April 2014, just after the engagement of Ryden. It was also circulated to Ryden. I hope I do not mischaracterise this evidence when I say that Mr. Hyatt, the inquiry's expert, is slow in his report to criticise an architect, such as Studio E, who might have relied on what it was said on the face of the BBA certificate when making a decision to use PE, particularly in its cassette form. But the BBA certificate misrepresented the position. In January 2008, when the certificate was issued, there was no Euro Class B classification for Rainer Bond PE in cassette form as used at Grenfell Tower. By December 2014, Rainer Bond panels, even in their riveted form, had been downgraded to Euro Class C. Rainer Bond cassettes were certified as being, at that stage, Euro Class E. The certificate was now, at this stage, and remained, misleading with regards to both Rainer Bond PE in its riveted form and to Rainer Bond PE in its cassette form. The BBA certificate continued to state that Rainer Bond PE was Euro Class B, and for that, that for the purposes of approved document B under the building regulations, such panels may be regarded as having a Class O surface. Arconic did not notify the BBA. The certificate was not altered. The first purchase order for Rainer Bond cassette PE to be used at Grenfell Tower was not placed with Arconic by CEP until the 18th of March 2015. I just should add, as far as we are aware, at no time prior to the fire was the product tested to part 6 and 7 of BS 476. There was necessarily, therefore, no test to show that it met the definition of Class O contained in Appendix A of approved document B. It appears that the reason why the terminology may be regarded is used in the certificate is that there were no test results showing Rainabond PE was class 0, and that the conclusion was an assessment based in part at least on the Euro Class B rating. Arconic nonetheless continued to use the BBA certificate to promote sales of Rainabond, and did so specifically in the case of Grenfell Tower. It is notable against that backdrop that in May 2013, and I refer to an email of the 13th of May 2013, reference CEP 000049717, that Arconic's representative in the UK had emailed CEP and Harley subcontractors, assuring CEP that as a result of the very close working relationship between Arconic and its very small group of approved fabricators, of which CEP was one, Arconic would make sure that the right technical support, Rainabond specification and materials are being used and installed on Rainabond projects. As already mentioned, on the 23rd of April 2014, Arconic emailed a copy of the BBA certificate to Harley and CEP, and we suggest that that could have only been done to give comfort to Harley and CEP and informed the decisions that they made. It's not surprising in that context that at paragraph 63 of its opening submissions, Harley says that if it had known that Rainabond PE in cassette form was classified Euro Class E, as it was, Harley would not have considered it as safe for use. Finally, there are the further following features of Rainabond PE to have in mind, and Arconic's position. During the refurbishment, Arconic knew that the cassette panels were to be used at Grenfell Tower. They knew that Grenfell Tower was more than 18 metres. They knew that Celotex FR5000, basically the same product as RS5000, was to be used. Arconic had been sent the outline specification by CEP as early as the 24th of January 2013. In that regard, we refer to an email from CEP to Arconic enclosing the outline specification dated the 24th of January 2013 at CEP 000048962. Worse still, we have seen recently information which suggests that Arconic knew that Rainabond PE in general, and cassette form in particular, was dangerous. To highlight what may be just the tip of an iceberg, we draw the following to the inquiry's attention. On the 30th of June 2011, Claude Verler emailed Guy Scheidecker, the sales and marketing director of Arconic, stating amongst other things this, and I quote, "The classification obtained for the Rainabond PE cassettes is the same as that of competitors, i.e. F, and therefore not suitable for use on building facades, M4 in France, for example. The reference for that is MET 000053158 underscore P04 underscore 0027. A few days later, on the 6th of July, Mr. Verler wrote an internal report of a meeting he'd held the previous day with a competitor. This report is at MET 000536161 underscore 0021. Under the heading, and I quote, European Fire Regulation, he noted, Rainabond PE in cassette form was classified Euro Class E, but a B class is the minimum required for a facade in Europe. He went on, for the moment, even if we know that PE material in cassette has a bad behaviour exposed to fire, we can still work with national regulations who are not as restrictive. Some countries, Spain, already working with EN 13501 standards, and the PE in cassettes is no more usable there. He goes on, the evolution of fire regulation will put the PE out of market in the coming months. It is difficult to give a deadline due to the inertia of European commissions. Mr. Wöhler is also recorded on the same document as stating that an action point for himself was this: analyse how we can have a D call with PE cassettes, maximum class possible, and usable in some small buildings. It seems quite clear that in 2011, Arconic already considered that Rainabond PE cassettes could only be used in some small buildings. Some years later, on the 29th of June 2015, a year or so before completion of the project, and 2 years or so before the fire, in the context of discussing the use of PE and the French national standard, NFP 92, Mr. Wöhler said this: my opinion, PE is dangerous on facades and everything should be transferred to FR as a matter of urgency. The NFP 92 standard, the French standard, which could be interpreted as allowing its use, he said, and I quote, should have been discontinued over 10 years ago, close quotation marks. He finishes by saying this opinion is technical and anti-commercial, it seems. And that document can be found at MET 000531558_PO5_0014. Harley, at paragraph 62 of its opening submissions for this module 1, refers to an Arconic marketing literature produced in December 2016 after installation but before the fire, which states of Rainabond PE that it is only suitable for use in buildings up to 10 metres in height. Harley says that if it had had that advice, it would not have used Rainabond with a PE core in the facade of Grenfell Tower. I move, if I may, finally just to consider Celotex. Celotex, and again I look at this in the context of the analysis of witnesses of facts, decision-making, the way in which they made decisions. Celotex throughout knew that Celotex RS 5000 was the installation to be used at Grenfell Tower. They knew that Grenfell Tower was over 18 metres. They knew that it was to be used with ACM cladding, and that appears from Celotex written opening paragraph 108.4. It will, of course, be explored during evidence, and there's a total lack of clarity from Celotex, but there are varying degrees of suggestion that Celotex knew that the cladding was to be Rainabond, that it was Rainabond PE, and that it was in cassette form. We do know that on the 11th of February 2015, Harley provided Celotex with a Dropbox link to its construction drawings, and on the 8th of April 2015 and the 20th of May 2015, there were meetings between Celotex and Harley to discuss the installation of RS 5000 at Grenfell Tower. By that time, it was clear that Rainabond PE in its cassette form was in fact to be used, the first patch having been ordered by CEP in about March 2015, we think. If Celotex did not know the details of the cladding, it seems they could have easily asked. Celotex also knew, of course, that their RS 5000 installation is made of PIR, and it was not compliant with paragraph 12.7 of the approved document, and that was because it is not of limited combustibility and will burn. We get that from Celotex's opening paragraph 20.2. The inquiry will investigate how, in those circumstances, it came to be specified for use at Grenfell Tower. The specific and detailed history of the marketing and certification of Celotex RS 5000 is, of course, the subject matter of Module 2. But we do point out, even at this stage, that is reasonably apparent from documents already disclosed, that in about 2013, Celotex set about trying to break into the lucrative above 18-metre market for cladding insulation. It also seems clear that at that stage, the market was then dominated by Kingspan K15, and Celotex sought to break into the market by obtaining a BR135 certificate for an existing PI product of theirs, that is the FR5000. To get that certification, the BR135 certification, they had to submit a complete rain screen cladding system for testing, of which the PIR insulation, which would be one element. Identifying a suitable system to submit to the test proved a difficult task for Celotex, given the combustibility of both the PIR insulation and that of the ACM cladding panels typically being used at that time for rain screen cladding. A Celotex internal email dated the 1st of November 2013 has been identified by more than one poor participant's written opening as being relevant. The email was written during the course of attempts to obtain BR135 certification, and it referred to the difficulties. This document of the 1st of November 2013 can be found at CEL 50716. But I quote from this document, and this is Celotex. We cannot seem to find a design, a suitable barrier in which we have enough confidence that it can be used behind a standard ACM panel, in brackets, which we know will melt and allow fire into the cavity. After going on to discuss the options for setting up BR135 tests, the email concluded, or do we take the view that our product realistically shouldn't be used behind most cladding panels because in the event of a fire it would burn? Notwithstanding this assessment of unsuitability, Celotex submitted FR5000 for its BR135 certification. Celotex failed in the first attempt at obtaining BR135 certification, but succeeded the second. They did this only by using a combination of cladding panels and other component materials that were different from those typically being specified and used in the industry for rain screen cladding installations. We now know that one of the unusual components used in the successful test was 6mm non-combustible magnesium oxide board used as reinforcement in the area of the cavity barriers. This magnesium oxide board was intended by Celotex to improve the performance of the system and contribute to the passing of the test. There are three matters arising. First, BRE's test report made no mention whatsoever of the use of the magnesium oxide reinforcement board. Secondly, Celotex took the conscious decision, it seems, not to ask BRE to correct the report by including a reference to the magnesium oxide reinforcement. Finally, Celotex also took the decision not to refer to the fact that magnesium oxide reinforcement board had been used when describing the test in their marketing material. Since a BR135 test is only valid for the particular combination of materials used in the test, omitting reference to any of the materials was itself deliberately misleading, we say. The BR135 certification was for FR5000, a product which Celotex acknowledged had only ever been marketed for use as pitched roofs, walls and floors and the like, but never for use in a rain screen cladding system in buildings over 18 metres. I should just pause here to say that the designation FR5000 does not appear to relate to anything to do with fire-related or fire-retardant material. In August 2014, however, Celotex began to market RS5000 as being appropriate for use with rain screen cladding and on buildings over 18 metres. Mr. Hyatt identifies that FR500 and RS5000 are in fact the same material, and Celotex in their evidence appears to accept this to be the case. In other words, it's simply marketed differently by Celotex, with RS being sold, as we understand it, at a higher price. RS5000 is therefore the same material, to which the discussion that we see evidenced in the email of the 13th of November 2013 applied. In relation to Grenfell Tower, FR 5000 was specified for use in the NBS specification sent out to tenderers, including Ryden, as part of the invitation to tender process. That in November 2013. When Harley first asked Celotex on the 10th of June 2014 whether they had an insulation material for use over 18 metres, we understand that Harley were told at the time that Celotex could not assist. At that stage, RS 5000 had not been launched. However, following the launch of RS 5000 at the beginning of August 2014, and on the 27th of August 2014, Celotex contacted with Harley with information about RS 5000, which was described as a product for use over 18 metres. Again, as we understand it, a Celotex product data sheet, and that can be found at CEL 708, provided to Harley, in which Harley subsequently emailed to Studio E and Ryden, stated in its headline banner as follows, and again I quote, Celotex RS 5000, premium rain screen cladding board, suitable for buildings above 18 metres in height. It continues, RS 5000 is the first PIR insulation board to meet the performance criteria in BR 135 for insulated rain screen cladding systems, and therefore is acceptable for use in buildings above 18 metres in height. It is the first PIR insulation board to successfully test to BS 8414, meet the criteria set out in BR 135, and therefore is acceptable for use in buildings above 18 metres in height. Has Class 0 fire performance throughout the entire product in accordance with BS 476. Under the specification clause, it says RS 5000 has been successfully tested to BS 8414/2 and meets the performance criteria of BR 135. When considering the evidence of those who made decisions in Module 1, we invite the Quarry to have in mind the following. Celotex was aware that the BS 135 classification was applicable only to the very particular system that was tested. The data sheet at the back of the document and on its last page stated that fire performance and classification report issued only related to the components detailed above. The headline banner statements on the front page that it was suitable for use over 18 meetings was unqualified. It was misleading. Furthermore, the reference to Class 0 fire performance throughout the entire product, as has been pointed out by others, including Dr. Lane, is misleading, or could be taken as being misleading, since Class 0 only applies to the surface or of linings. The fact that the description of the specific cladding system that had been tested was the only system certified in any event deliberately failed to refer to the additional use of the magnesium oxide board reinforcement. The fact is that despite a very different specification for the cladding system used by Celotex to obtain the BR 135 certification, and that specified for Grenfell Tower, no concerns were raised by Celotex about the suitability of Celotex RS 5000 for use in the Grenfell cladding system. I appreciate, sir, that I have trespassed on matters which I know will be considered in the Module 2 aspect, but we do consider that when looking at decisions which were made by those during the course of the refurbishment project, that those matters should be at least in the background of the inquiry's mind. Mr. Chairman, I'll finish Ryden's opening remarks there, if I may. I thank the inquiry for considering our written opening and for the opportunity for this oral opening.
Well, thank you very much. Thank you. Well, it's just after 1:15, and I suggest that might be a convenient time to take a break for lunch. We're getting on very quickly as far as today's programme is concerned. So I'm going to say that we'll resume at 2 o'clock, when we will hear from Mr. Laidlaw on behalf of Harley. So we'll rise now and resume at 2 o'clock, please. Thank you.